Good morning, ladies and gentlemen. Welcome to another episode of Property Law Alliance. We have today, we're dealing with one question, and we'll just put it on the table, and perhaps Bruno and Nick can both have a decent bite at it. So this one is just a simple lease agreement versus failure to pay rent, right? So there is a tenant involved, and then the tenant has just failed to simply pay rent as per lease agreement, and then the landlord then had wanted to the tenant requested the landlord that, hey, can I please still stay in the property for a further 3 months, all right? And then what the landlord did is they canceled the lease agreement, and then the tenant came to a verbal agreement with the landlord that, hey, I would like to stay in the property for the 3 months, and I will then pay rent for the 3 months. So the question then becomes, is there any risk to this? Is there any risk in letting the tenant stay in the property for that 3 months via verbal agreement, or is there any legislation or any sort of formalities that should be put into place if you're going to be doing or if you're going to be allowing the tenant to stay in based on that agreement alone? So maybe Bruno and Nick, you can just perhaps have a good answer at that question in that scenario.
Cool. Who wants to go first?
Oh, you spoke first. You might as well.
Nice. All right. So first thing that we need to bear in mind, if we're asking the question, what is the risk of allowing a tenant to stay on a property once they've defaulted? It's a rather big risk. So you keeping on a defaulting tenant that historically has proven that he's an ability to pay. So by keeping him on, you're just basically dragging out the inevitable for under most circumstances, unless for some reason you know that he's good for it. So the biggest risk is continued non-payment. However, a 3-month period, especially compared to the time periods that some evictions take, if you can get the tenant to agree to move out within the 3 months, 3 months is a good number. It's not actually all that bad, simply because getting the eviction order sometimes does take a little bit longer if the person resists. So it's a bit of a balance, because they might not resist. They might move out as soon as you issue the application, or they might stay for a little bit longer. So between like 1 to 3 months, sometimes it's a bit of a gamble, but it's not always a bad idea to take it. So it's kind of the balance between the practicality of allowing a defaulting tenant to stay on the property. Now, legally speaking, what does this actually look like? And obviously, so I don't ramble on for long, Nick can jump in and speak about just like as an example, would it be a novation of the lease agreement? If you've cancelled and now all of a sudden you're letting the person stay on for a little bit longer, and then I'll probably jump in back later and make a couple of suggestions on ways that you guys can maybe get around it.
Yeah, so I think what the important thing is with regards to settlements is obviously, like you mentioned, Bruno, when we do evictions, there's obviously a time process which the eviction process takes. And then also what's important for a lot of landlords to understand is when you eventually get to court and eventually an order is made by a magistrate, the magistrates are going to make a determination of what's reasonable in the circumstances for the tenant to vacate the particular premises. And this often, especially in residential circumstances, means that the magistrate is going to make a determination that the tenant must vacate within a period. Generally that's a month. You give the tenants a month to vacate the premises, but it can be longer. It's within the discretion of the magistrate. So something that's very important when you're talking about settlements is to consider the fact that even if you brought the legal proceedings, and even if they were very quick, there's still going to be a period which the magistrate is likely to give them to vacate. So I just wanted to bring that in, because I agree with Bruno in the sense that you're saying, well, if it's a 1 month or 3 month period, I know a lot of landlords, they get tired and they don't want to give any leeway and they want the person out of the property. Yeah. And I understand that sentiment, but really, in terms of South African law, in terms of our courts, we're encouraged to settle matters. And in particular, if you just look at the results of an eviction, even a successful one, there's still going to be a time period that a landlord is going to have to endure, regardless of how successful you are in front of the court. So really, it's something that needs to be considered. Now, with regards to novation, the reason Bruno has mentioned this is landlords need to be very careful. Okay, as we know, lease agreements in South Africa do not have to be written agreements. Okay, you can have verbal or tacit agreements. Now, verbal is basically you and I agree verbally, we don't write it down, and we agree that there's a lease. Okay, and we just work on that verbal contract. Tacit is an agreement where, say, you didn't specifically verbally speak about a lease agreement, but the party's conduct is that it shows that a lease agreement is in place, i.e., you as a landlord are letting someone use your particular asset, and the tenant, in the circumstances, is paying remuneration for the use of that particular asset, and there's no disturbance between these two parties. So the landlord's not immediately saying, you can't use that thing. The landlord, in other words, is receiving this remuneration. Okay, this is a circumstance where a lease agreement can be implied between the parties. Now, the reason I mention this is you need to be, as a landlord, very careful. Okay, because the formation of a lease agreement can come into place even where you might not think that you're actually entering into a lease agreement. And this is why when attorneys get lease eviction instructions, we're very careful about things like issuing further invoices to our tenants after the cancellation of the lease agreement. The mere fact that a invoice goes out and is then paid by the tenant, and then the landlord receives the money, might mean the formation of an implied lease agreement, even though expressly on a written document you've cancelled. I don't want landlords out there to worry. There are obviously certain things that protect landlords in the circumstances. We do have clauses within general lease agreements, or good lease agreements, which protect and say, look, that the accepting of rental after the cancellation is not going to prejudice the landlord in the circumstances. But there needs to be some consideration for the fact that another agreement which is entered into between the parties, even though the lease agreement has been cancelled, can form a different agreement, which the tenant can then rely upon. So when it comes to settlement agreements, there needs to be some level of care which is given by the parties, okay? And in particular, the landlord. If you as a landlord cancel your lease agreement and you do it expressly in accordance with, the terms of your written document, the tenant now asks for a further period to reside within the premises, and you agree on some level of rental or whatever the case is, you can sit in a situation where you risk creating a new agreement with this tenant and novating the previous lease agreement. Okay, so novation, for those of you who don't know, it simply means that you have an agreement which takes place of the former one. Okay, that's the simplest way to explain it. So you need to be very careful, because you can novate what lease agreement you would have had with another agreement which may be on the same terms as the original written agreement, or depending on what you guys agree on or what conduct you're doing, might be completely different terms. And that can create a new right for the tenant to occupy your particular premises. So you do need to be careful when you're negotiating settlements. This is not to dissuade people from negotiating settlement. As I say, it's a key part of what we do in this industry, but some care does need to be given to make sure that when you come to settlement, you don't create another agreement which the tenant then relies on. It says, actually, I'm now occupying in terms of this further agreement.
So that's 100%, totally agree with that. And what we find happens is, especially when it comes to longer time periods, so shorter time periods, like fine, move out next week, one can almost say that there was an intention to create a valid and legally binding new lease agreement. It can be seen as a settlement of sorts. Whereas if you start looking at longer periods of time, I've had people try and settle on 6 months, 7 months, with the payment of a rent, but slightly escalated, with payment of arrears, with AODs. And the reality behind it is, remember, the legislation in South Africa that deals with evictions deals with the word consent, meaning that there has to be some kind of consent by a landlord for somebody to stay on the property. And we rely predominantly on the unlawfulness of a person's occupation. So if you can now argue that the occupation has now been made lawful again because the landlord has said, yeah, okay, no worries. Unfortunately, in those instances, you'd have to follow the cancellation process again. So it's not to say that, I mean, you'd basically lose a month for all intents and purposes, because you'd have to send out that notice and you'd have to cancel properly, right? But if the guy's not paying rent and you're giving him 3 months and it might be rent free, that does create like a huge burden on you to now have to send out another notice, spend another 21 working days, ask him to remedy the terms of this new lease agreement. What I normally do, and Nick, you might have your own strategies for doing it. The one thing I like to do is issue the eviction application in any event. Because, the guy's unlawful, he needs to get out of the property. Do the settlement agreement, prepare the settlement agreement as one word, but use the case number for the eviction application. And you basically rely on the fact that there's an eviction application, a court process has been instituted, and you're settling in terms of this process. So that for me is the safest, cleanest, never had a problem with it. And if anything does go wrong, you've issued an application. It's fantastic. The time periods in terms of the application are running in the background. So they've got X period of time to defend or oppose, which they haven't. So sometimes it's actually a matter of just following the process and then trying to get the settlement made in order of court. And it's not always the fastest thing, but it's certainly faster than having to cancel again, institute afresh, and wait out the time periods for these guys to oppose. So that for me is the first prize. I have experienced situations, for example, where the clients don't necessarily want to follow a court route and are looking for a shortcut, slightly riskier way of doing it. And Nick has mentioned it before. So keeping people on, but sending statements that have the word rent in it, not a great idea. So at the very least, start utilizing the correct terminology. So holding over damages is basically rent. It's the value of rent, but it's not rent. Rent implies is an agreement, and rent is due in terms of a lease agreement. Damages are due after a person breaches or causes any form of damages, being derelict or contract. Bottom line is, if you claim damages, it means that the person's doing something wrong and you're being compensated for what they're doing wrong. So even the use of terminology, even expressly putting in an agreement going, you've asked for 3 months, you express your intention going, I don't want you to stay here. I'm not consenting to you staying here. The only reason I'm allowing it to happen is because the court process takes so long anyway. So so move out. These are the circumstances. I do expect you to compensate me with damages, because it's taking you so long. But please do not take this as a consent. In fact, move out of the property sooner. If you move out the property sooner, I will actually be happier. That sort of thing. I know it sounds weird, but if you're going to DIY it, be very expressed that this is not something that you're happy with, and be expressed on the only reason you're doing it is because things take so long anyway. So this is pretty much the only option you feel you have. I don't know, Nick, any other?
It's a great suggestion. If you are going to reach a point of settlement where the ex-tenant now, because you've cancelled, is going to vacate the premises at some point, but they need an opportunity to do so, some time, don't charge them rent. The use of the term rent is an implication that a lease agreement is in place. The correct term would be holding over damages. So that implies already that you are holding this property when you don't have a right to do so. That's a very simple way of ensuring that you get yourself to the point where no one can then, if you signed a written settlement agreement or there's some communication, it's very easy then to point and say, look, there is no rental payable. This is a holding over damages compensation. And so there is no lease agreement in place. It's a very simple way of doing things, which can save you a lot of time. And I will say, with your suggestion to institute proceedings and continue with proceedings, I wholeheartedly agree. One of the interesting things that we experience in practice when you're sitting in front of a magistrate or a judge, one of the things that they have a duty of considering when it comes to evictions is the just and equitability of evicting a person from a premises. And the reason I mention this is we have had settlement agreements which have been concluded with tenants, and it's all agreed, and they're going to vacate the premises. But judges and magistrates still have a duty to overlook this process. Okay, there's a specific process that has to go on with evictions. That process has to be followed irrespective, okay, before someone can be ejected from a premises. And even presenting a settlement agreement to a court, the court, yes, you know, for the most part, the court's going to look at that settlement agreement and is most likely going to follow its terms and agree that that is, you know, that's how the circumstance is going to play out. But I have had experiences where, you know, magistrates or judges look at a settlement agreement and still they say they're not going to follow this to the letter because they do have an obligation to actually assess the justice and equitability of the order that they're making, regardless of what you've agreed to in the settlement agreement. You know, they still have to perform that function. So absolutely, continue with your legal proceedings, have them there. The settlement agreement is very helpful. But you know, and put the settlement agreements in front of the court. Do it on the court's letterhead, like Bruno suggested. But know that the court is still going to make their own determination, you know, regardless, even if you put that settlement agreement in front of them. So it's good to keep the legal process running in the background.
Sure. And it's funny you say that. So we've had experiences, one, not an eviction matter, but settlement agreement before court. Court removes it from the roll for some other reason, right? We didn't get good reasons for it. And unfortunately, that day, it seemed a lot was being removed from the roll. So sometimes there's no proper explanation on why magistrates or judges are acting in a very particular way. So number one, bear that in mind. Just because you have a settlement agreement does not guarantee you an eviction. And there's actually case law to this effect. There was obviously on a larger scale, but in this building, there were a few people that proclaimed to represent other people, and they entered into a settlement agreement. And eventually the other people decided to go to court and say, well, we didn't really understand what was happening. So, you know, there was no meeting of the minds. And the court set aside the order and said, well, sorry, eviction wasn't granted properly, circumstances weren't considered, these people's rights weren't considered, so we need to redo it. So as Nick mentioned, we still follow the process. So to make this an order of court, we still actually follow the rules, give notices again, make sure that everyone on the premises knows what's happening, even if you have a signed settlement agreement. But it's the safest way of doing it, because it might actually make the difference between 2 months without rent and 7 months without rent, just if you act as quickly as possible and diligently.
Yeah, absolutely. Well, I think we've covered that actually quite extensively. Yeah, the settlement agreements, obviously one has to navigate them through them very carefully. It is clearly a very slippery slope, especially in terms of, I think the minute you do have a defaulting tenant, it automatically becomes a very difficult situation to handle. The minute your emotions, if they get involved, it can get out of hand. So one has to be careful, especially in terms of accepting then further payment and getting people stay on, and how that then becomes communicated. It can literally extend things to something that becomes out of your hands. So thank you very much, gentlemen, for that insight. And yeah, I think that's where we'll end it for today. If there's not any other further things you guys would like to add.
No, I'm good.
Good.
100%.
All right, thanks, guys.
Cool. Thanks so much, guys.
Thank you.
See you next week.
Cheers.
Yeah.